Hello, everyone. My name is Shannon O'Loughlin. I'm a citizen of the Choctaw Nation of Oklahoma, and I'm the CEO and attorney for the Association on American Indian Affairs. I've been working on NAGPRA issues for over 20 years. I have served on the NAGPRA Review Committee in the Department of Interior, and I've also served on the State Department's Cultural Property Advisory Committee until I was fired by a previous president who shall remain nameless. And that's me. So without further ado, let me bring on my other cohorts here. Judy, would you like to introduce yourself next?
Sure. Hi, I'm Judith Shapiro. I'm a lawyer in DC, and I've been practicing tribal law for 36 years now. I used to be a lot younger. And in the course of that, and representing tribal interests, some of it has been NAGPRA, most of it has not. But a lot of it is working with tribal interests. I will confess an undergraduate degree in cultural anthropology that perhaps informs how I relate to this. And I was fortunate earlier this year to work with Shannon in helping to develop the association's comments on the proposed NAGPRA regulatory revisions. And I'm here not so much for my depth of NAGPRA, but my stone throwing ability.
Thank you, Judy. Dr. Wendy Teeter.
No, I wasn't expecting to go second. There are so many more esteemed people than me. But I am really happy to be invited to this panel, and so many of you that are just watching are actually mentors and people I highly respect. So I am certainly appreciative. I am the senior curator of archaeology for the Fowler Museum and UCLA's repatriation coordinator for another 2 months, and then I'm retiring after 25 years at UCLA, and am now the cultural resources specialist for the archaeologist for the San Ynez Band of Chumash Indians, where I'm calling from right now. So I look forward to this conversation. Thank you.
Very cool. And next up, Dr. Veronica Pasfield.
Ani, Veronica Pasfield, Indigenous Jujucando name. I'm Veronica Pasfield. I am a NAGPRA officer for Bay Mills Indian community, as well as a historian and a journalist. And I've been doing this work since around 2010. It's nice to be with you.
Thank you. Do I call you doctor or you and Wendy? So Dr. Veronica?
Yeah,
does that work?
Okay. And if you want, I do have a PhD. So,
and last but definitely not least, Ms. Melanie O'Brien.
Hello, everyone. I hope you can hear me okay, but not hear my dog. That's why I shifted to the headphones. It's great to be here for this session. And I am Melanie O'Brien. I am neither a doctor nor a lawyer. I am merely a bureaucrat. So I am the manager of the National NAGPRA program. We are housed within the National Park Service, but we carry out the responsibilities of the Secretary of the Interior for the administration of the Act. So if you read the Federal Register, you will see my name repeatedly over and over again, because one of my main responsibilities is to publish Federal Register notices for repatriation. Our panel today is actually designed as a more of a discussion, a conversation. Those of you who might have attended the conference last year might remember that I hosted a Mythbusters session where we talked about some of the main myths that I encounter in NAGPRA work, and then invited people to speak to both sides of those myths. We have something kind of similar for you this year, although slightly different. And I have developed a couple of scenarios with questions, again, based on experience and encounters I have in the real world of NAGPRA. And then the esteemed panelists will be sharing their thoughts on these topics. So I'm going to share my screen so that everybody can see these. And true to our general nature, we are going to just chat. We're not going to have any kind of formal mechanism for who gets to talk when. We're just going to kind of walk through these scenarios. And as I feel like maybe we're wrapping up, I'll move on to the next one. So our first one is about cultural affiliation. So here's your scenario. Human remains were removed from an unknown site, but from a known county and state. The earliest human occupation of that county dates to around 10,000 BCE. The human remains are not dated, but they likely are likely post-archaic, meaning after 500 BCE. There's no information that shows the remains are historic. Multiple earlier groups have occupied that county over a very long period of time. And 15 present-day Indian tribes claim ancestral occupation of that county at different points in time, sometimes overlapping and sometimes conflicting. Can these human remains be culturally affiliated?
Ooh, I know the answer, but I want to hear from Dr. Wendy Teeter, because she's making these kind of decisions all the time in her position.
Well, thank you. Yes. And the answer is yes, right? And I would definitely say I've seen these scenarios over and over again. And this is where the really important work begins, because you have to do consultation. And knowing that even if you have 15 tribes, all of them could be culturally affiliated. It could be even more. And through that consultation and talking to tribes, then they will help you understand the history better for these ancestral remains and help you culturally affiliate and get them home. So it's through the consultation process, and we can't stress that over and over again, that so much of this work should begin and end.
Also, Melanie, I wonder, or anybody on this call, I feel like I regularly encounter people feeling surprised or even skeptical, tribal implementers, that you can about a shared group identity claim. And I wonder, I feel like it would be beneficial to just talk about that just a little bit, because of I don't think it's as well understood as it could be, and it's really useful.
Yeah, I'll kind of set this up, and then maybe I could turn to Shannon and Judy to continue the discussion. I think, when I say cultural affiliation, I mean the definition in the Act and the regulations, which is a relationship of shared group identity between an earlier group and present-day Indian tribes. That is basically what we're looking for, is a shared group identity.
Yeah, and that sounds just there. It sounds much different than some kind of scientific or research project to try to clarify what particular tribe or tribal group at a certain historic period of time or pre-contact period of time was affiliated. Judy, you were about to say something. You were on mute.
So doesn't this also hark back to the most recent panel about tribal coalitions, that it can be, the consultation process can be enriched if it includes as many as possible of those potentially conflicting claims. If the various tribes that have gone through there are all together in the room during the consultation, then you have an absolute likelihood of identifying adequately some cultural affiliation within that coalition.
Yeah, and since we're talking about this in context of the NAGPRA regulations and the potential for change in the NAGPRA regulations, DOI's draft proposes very clear language about joint requests for affiliation and repatriation. which I think will suit this situation much better than the current regs suit it. What do y'all think?
Well, I would jump in first to say that I would ask the tribes individually if they want to do a joint consultation and to respect their sovereignty. And certainly there are some that will do coalition building and some of them that would prefer to speak on their own. So I never force a tribe in a group setting. I want to first respect what their views are individually and how they'd like to proceed.
Good answer. Yeah,
One more thing I want to speak to this, just because we have definitely encountered this sort of question in Michigan with Michigan tribes. And it's something that we had to strategize around when we were implementing NAGPRA and sending out our claims and requests. And this is kind of, very kind of frontlinesy, I don't know if it's a particularly sophisticated thought, but just want to share that I have been surprised and not surprised at how much peer pressure really influences the decisions that anthropologists, archaeologists, curators, et cetera, how much that influences how they proceed. So I just want to encourage people, if there are people in this conference who are experiencing peer pressure, not to affiliate remains that are, older than a certain time period, or peers who want to say that it is somehow antithetical to affiliation to have multiple groups existing in a place over time. That oftentimes this is a paper dragon. So I had the opportunity to speak to one of the state historic, one of the SHPOs in a state that just had a large repatriation to multiple tribes, and was a little bit worried about this, and did get a little bit of pushback, a little bit of attitude from his peers, but really is very happy with how it all went down, and that the ancestors are back, and now the resources for the tribes as well as the SHPO office can be focused on other things. So I just wanted to share that encouragement.
Yeah, my issue with scenarios like this, and what I often see, or what I have seen with institutions, is they get hung up on the time period and the era. That if it's too old, somehow there cannot be a shared group identity with ancestors that are older than a certain period of time. I remember when we brought a claim to the NAGPRA Review Committee about some ancestors that were 800, 1,000 years old. The New York State Museum actually, we found that they had a written policy, an internal written policy that categorized all their ancestors by age. So if it was beyond 300 years old, they would not affiliate those ancestors. And so that by bringing that dispute to the NAGPRA Review Committee, we were able to kind of put transparency on that policy for the NAGPRA Review Committee to say, no, that has nothing to do with NAGPRA. NAGPRA does not have any kind of limitation based on how old the ancestors might be.
Can we have a colonization moment on that one? That to say that history started when the state of New York started keeping its records is more or less obscene. Actually, more.
Right.
I completely agree. I didn't want to be the one to start that. And I'm so glad you said that, because I feel that what that does is that plays into this, extinction and authenticity sort of parallel narrative within settler colonial society. And it's bogus. And if we look at archaeology and anthropology are both firmly rooted in those horrible ideas that are white supremacist and racist. So I am all for rejecting that really loudly every single chance we get.
Well, I think that's where, I would say the issue in this scenario kind of lies in the fact that there is no date. So perhaps say if we could date these human remains to a contact period, or just before, then there might be a clear cultural affiliation in some museums' minds. And the fact that there is this 2,000-year span where, we know that multiple different groups occupied this location in that 2,000-year span, but we don't know which ones these human remains belong to. And so therefore, we don't know which group, which present-day tribes the human remains belong to. That's often the argument we hear. Wendy, it reminds me a little bit of a kind of a side conversation you and I had recently on a discovery of some ancient Irish remains, I think they were, or Scottish or something. And my comment was, wait, how can they be that old and still be related to present day people who live in Ireland and Scotland? That's impossible. In the US, everything was erased at contact and started over.
Absolutely, but it also reminded me of a case that took a long time. We had to wait for the CUI regs to actually be created in order to return some ancestors that we knew that they were from a location, a shell mound, and so we spoke to all of the tribes in that area, and they figured it out, and they gave us who should be culturally affiliated. They were all working together. And still, because we were a part of the UC and those decisions were being made above the individual campus, we were refused the opportunity to return these remains until the disposition, until 1011 came to be, and they refused to acknowledge this cultural affiliation. We had to do it as a CUI. So it really has a tremendous impact. And that's why I keep going back to, consultation, because the tribes and our panelists the last session were so wonderful in speaking to, well, actually all day. We're great about speaking to this issue that they figured it out. They're doing these cases over and over again. So if we look to the tribes for assistance in doing this, as the regulations actually require consultation, we can usually get these things sorted, and they can help us out.
There's a question, and I want to just bring it up. Shannon, you answered, but let's go ahead and just briefly at least talk about it, and then we'll go on to the next scenario. And the question is, has modern cutting edge DNA technology helped in demonstrating cultural affiliation? What we would say at the Department of the Interior is no. DNA is only one line of evidence. It's biological. And it just adds to your biological information. It doesn't necessarily counter other evidence or weigh heavier. It would be a matter still of weighing all of the evidence you have, and including that DNA technology if it's available. But again, I would remind everybody that NAGPRA does not require, nor does it prevent, but it does not require any scientific study, any additional analysis of remains in order to be culturally affiliated. Shannon, do you want to add to that?
I think maybe Judy wanted to. Did you, Judy?
A little bit. This is, Melanie, this is the question that I sort of threw at you yesterday about available evidence and how does that bias the whole system. And if it is a question of what's available, of course the technology is available, but then of course there's no reason to use it. There's no reason to do any of the science project stuff. If this is a statute, and I'm going to go back to this over and over, if this is a statute which has as its goal, not congressional intent, but the actual language of the statute, there's a presumption of repatriation. If there's a presumption of repatriation, which is to be accomplished through consultation, then your available evidence is what you get by consulting with the affected beneficiaries of the statute. And that's enough. And if there's more around, fine, but you don't have to wait for more to be around, because that's not the point of the statute. And my feeling, jumping into this a little bit more naive perhaps, but with my lawyer tools intact, is the presumptions have to be as the statute sets it, and the regs have to follow the statute. And that I think is going to be our task.
Yeah, I think, Judy, we've talked at length about how important it is to have fresh eyes on some of these words that we all take for granted, I think. And when I say available information, I'm kind of trying to make it easier to understand what the statute says. And the statute says information possessed by the museum or federal agency. So you're absolutely right. Available, may be available anywhere, or you may have DNA technology that is available, but that's not what you're supposed to use. You're supposed to use the information possessed by the museum or federal agency about those human remains to make your decisions.
And just to jump in there, there's actually then the what do you call it? The anti-liability, that once you've made that determination, repatriation happens. If, several years later, there's more information and I've had this happen where somebody goes, you repatriated to that group, and now there's this information. It's like, well, that's what we did. Like, that's it. Like, there's no chance that you're going to be sued. And I've heard museums say, well, we can't really figure this out and we don't want to get in trouble, so we need to sort it all, and that might take us 10 years. And you're just like, oh my God, really? So there is that support in the regulations for people afraid of making a determination at the time.
Two quick things to add to that. I remember when we were first really starting to implement NAGPRA in a new way in 2010 or 11. And I called and spoke to the National NAGPRA program, which has always been so welcoming and helpful. So really encouragement for the tribal NAGPRA officers out there who maybe haven't ever reached out. Like, we've always had our questions answered so beautifully there. So miigwech for that. But Sherry Hutt, the former director, had a really interesting conversation with me about how this idea of scientific certainty, that some museums are under that definition in the law, call for pressure for scientific certainty. And she said, even in criminal law, that scientific certainty is not the threshold for making a decision. So I just wanted to say that. And then also, I think the only other thing I would add to that discussion about DNA is that this is one of the places where I really see NAGPRA and its designation as a human rights law. If you are unlucky enough to learn that your ancestors' bones and teeth and skulls and mandibles have been broken apart and scraped out and smashed up to satisfy a museum or some faculty member's research agenda, that's a really horrible, violent thing, for me anyway. And I really appreciate that Congress did not ask us to endure more violence beyond the looting of our cemeteries. So I just wanted to share that connection that is there for me.
And that goes to, I'm really looking forward to the next question, because it's about control, right?
We had a mind meld there. I was going to say, and that leads very well into the next question scenario we have, which is about control. A large collection of items was removed from a well-known village site in the 1950s. The excavation was a collaboration between University A and Museum B. Baskets from the site were sent to University A, pottery from the site went to Museum B, and beads and shells were sent to Museum C. No written agreements exist regarding distribution of the collection. Records at Museum C only identify the name of the archaeologist at University A as the donor, but there's no deed of gift. A portion of the village site is now on federal land. Who has control of the collection?
Oh. And after 25 years, I've done all of these scenarios, so I can't help but. So first, I want to say that the federal issue is kind of out because this was removed before they took control. And I will say that the federal agencies tend to be the ones who say, unless you can prove it, that it was from our undertaking, and you literally have pictures of us removing it. Sometimes I even have permits, and they will say that they did not have control over the situation, and it's up to us. So yeah, good luck with the feds. So then you're back to the university and museums, and you actually have a ton of different scenarios that I've seen played out in this. The easiest thing is, and that we've done often, is to do sort of joint work together, and that makes it easier for tribes. So the university and museums, with their collective pieces, can or portions of the site, work with the culturally affiliated or potentially culturally affiliated tribes during consultation, and then we all put our names on the line of where it's coming from, and do that together. And that's easiest for tribes who are so often trying to search high and low for parts of collections that have been distributed across the country. And it's certainly less complicated. But you can also go through and do them individually. So each museum can, or university can, do the consultation and do their own notice of inventory completion. That's not prevented. Or they could transfer the collections over to one of those and basically give up any interest in doing NAGPRA, so that all of the collections are brought back together and you again have one notice. And of course, there's like a whole bunch of other scenarios that I've seen done that get more complicated, but just to sort of working with the tribes again become the biggest issue. And a lot of this, I've when we've had the situation, let the tribe kind of lead what makes more sense for them and who they have relationships with.
This question reminds me of the Meatballs movie. Are y'all Bill Murray fans? Meatballs? Do you remember this? It just doesn't matter. It just doesn't matter. They all have control. Each one of them have control of whatever is in their collections. The age, what status the land was, it just doesn't matter. They have it in their collections after November 16th, 1990. So they have control and they have NAGPRA obligations. And what's interesting about this is I love how all these little red herrings will just oftentimes make institutions and others just go crazy with all the little details that can pop up to slow down the process. So and what I learned a lot through the current NAGPRA draft regulations process and our work with tribes and with Judy and other lawyers, is that the act is written, like Judy said, with this presumption of repatriation. This is a human rights piece of legislation. It's a civil rights piece of legislation for the benefit of Native Americans and no one else. Native Americans and Native Hawaiian organizations and no one else. And the only exception to the repatriation process in the act, not the current regulations, they suck, but in the act, the only exception to repatriation is if the museum has a right of possession. Now, I don't know, I'm not going to point at Melanie and make her answer if that's correct or not, because I don't want to put her on the spot, but I guess I could.
Yeah. So first of all, Judy, I think we're getting a little bit of feedback when somebody else is talking, and I think this is the challenge of having an open conversation, is that we have to also keep muting ourselves. But I think there's no right answer to this question. I think you're absolutely right. There are red herrings here. I put those in intentionally. I may not be a doctor or a lawyer, but I was a teacher, and I know how to write a challenging question that throws you off the mark. So absolutely, there's a lot in here that doesn't matter. And there's also a lot of options, as Wendy pointed out, for how you might resolve these issues. I would say that it goes back to what your intent is. To maybe bring Veronica in here. I don't want to put you on the spot, but it seems to me like what we're talking about here is a problem that colonialism created. And why should we? What what does it mean if we then put resources into this problem of sorting out who has control?
Fine, put me on the spot. Okay, I think that, so first of all, yes, just because you came into our place and decimated it and spread things around as if they didn't matter to sort of enrich your collections, doesn't mean that we have to accept it, and doesn't mean that we don't have recourse. So every situation obviously is different, and some institutions will gladly work to solve the problem and to fulfill the intent of NAGPRA, and some will use every little red herring and excuse to block you, right? And so I've kind of, I think in Michigan, we had 2,200 ancestors who came out of the ground in Michigan in 18 institutions, and we saw the full spectrum of that. From people who are gladly like, just tell me what to do and come get your ancestors. We are good. We're so glad you called, to the opposite. So the part, and I think the National NAGPRA program has really helped us, and sometimes our tribal attorneys really help us, and sometimes they have not really dug into NAGPRA. So that's okay. Just keep asking and digging and demanding until you have fulfilled your obligation to your ancestors and the full love that you have for them. I think that's kind of an overview of how I feel about that. However, if I may put Shannon and Judy on the spot, because I think that there's a little kind of nested thing in here that Melanie, that you wrote, where you say in this question, in this scenario of control, that there's no deed of gift. There's no deed of gift for who actually has ownership of this split collection, right? These different people who have pieces from a site. And I have to tell you, when I was in the working group with the association and Shannon and Judy ruled out their critique of how museums misunderstand right of possession, it made the hair on my arm stand up. And if somebody could post a link in the chat to the association's recommendations for the proposed new regulations, I think that would be incredibly helpful, because I think you have to read it for yourself. They have stuck a spear into the heart of NAGPRA resistors, I feel, with this part of their recommendations for the proposed new regs. So that's my endorsement, and if you guys feel like it's a good time to talk about that.
I think it's a perfect.
Can I play? So my notes, which are perfectly illegible, say several places on this question, red herring, red herring. Not to belabor it, but the point of no deed of gift and the point of all of this is that ownership is the red herring here. There is the museum that got it, the college that got it. None of those people ever have a claim of right. And the only way they can have a claim of right is if they can document that at the time that it was severed from where it belonged, somebody with authority to give it to them did give it to them. Presumably they don't have that, but even if they did, it's their obligation, their burden to show it. So that, going back to what Shannon said, everybody's got a little piece of it. You can go after them all together. They can decide that we would rather get together and have you all figure it out. And what we said in our comments essentially is that the museums never have an ownership right. They don't have any property right. What they have is essentially naked possession. That doesn't give them a right to do anything but give it back. They have an obligation to give it back. And if they can't figure out who to give it back to, then maybe what we need to do some sort of system in the law in insurance cases. There's a thing called interpleader, where everybody agrees that somebody ran into somebody who shouldn't have been there, but nobody knows who's at fault. And so you just give it all to the court and say, here, you figure it out. And maybe this all goes to the NAGPRA Review Commission and to the secretary. And at some point you say, here are these split collections. They all agree or admit that they don't have a right to keep it, but they don't know where it should go. And then you either have a joint request or you have several requests and you figure it out. But in any event, it doesn't belong with the people who pillaged it.
Hear, hear.
Now,
I would
there were
love
lots
to, so sorry, can I just say one thing? In the chat, if you have experienced museums or agencies, federal agencies or universities or whoever who seems to think that they own the cultural patrimony and your relatives of your people, just like say yes or whatever, say no. I'm just curious of how many people have encountered this, because I sure have. And to have somebody plainly explain the law and these notions in the way that the association and way Judy and Shannon have done, I think is such an incredible service to Indian country. And I just want to like sincerely say Chimigwech for your work on that.
Yeah, I think I could have thrown a lot more red herrings in here. I could have said that Museum B never accessioned the items, and that University A, they were in the museum for a while and then they were moved to the Department of Anthropology. And I mean, we could complicate this in a lot of ways, but ultimately it comes down to, I think, intent and what is the objective? Is the objective to figure out who has control of each of these pieces? Is that where you want to put your resources? Is that where you want to put your effort? Or is your intent to repatriate? And I think that's where, when we get to these questions that really get deep and difficult, you have to go back to what's the outcome you want? And that will lead you then to the answer to these questions. I'm going to move on to the next scenario unless anybody wants to. Okay. All right, so here we go. Human remains collected in the 1920s are in a museum. The land from which the remains were removed was federal land in 1920, but the remains were removed without a permit. The collector sent the human remains to a colleague at a museum in 1930 for analysis. In 1995, the museum reported the remains, but identified them as a federal collection. In 2015, a researcher from Europe requested access to the human remains to conduct invasive but non-destructive testing. Can the museum authorize that testing?
Damn, that's a good question.
Oh, should I start then?
I think you should.
Because I've had this over and over again. I get these requests. So this does go back to if they're from federal land. So he looted, right? It was an ARPA violation. So they are definitely, and you're not supposed to allow any analysis, especially destructive, without federal conversation. But I would go farther. We've basically said that not only do you have to go to the federal government, but you have to go to all of the culturally related tribes. So in your red herring scenario, they should already be repatriated, right? So you should already be down that line, and then you don't have this issue. But we have seen where the federal government has allowed for destructive analysis over and over again, even if the museum has said no. And that's often come up to pass. And the federal government, some federal agencies have been very slow to not only do their notices, but to do repatriation. So it leaves museums in this position where our option is just to actually just sit it on their doorstep and say, if you're not going to deal with it, we're no longer going to house it. So this is a big problem.
So just to clarify a couple points, ARPA doesn't come to play until 79. These are collected in 1920. Still, probably there's some federal law involved there, but Museum, they kind of overlook that.
So
Shannon?
So it's in a museum. It's the museum's Native American collection. So it's NAGPRA. These are NAGPRA cultural items that should be consulted and repatriated. The issue is about this researcher from Europe who's requesting access to me. So the rest of the stuff to me is a red herring. The fact that it's after November 16th, 1990, these ancestors exist in an institution that's received federal funds, and therefore NAGPRA applies, period. And so the real question is just about this destructive testing that happens. And for us here at the association, what we would argue is that, like we discussed about control with the previous question, the institution doesn't really have a right to possession of these ancestors' remains because there was never any consent given by the tribe when those remains were originally removed from the earth. So then that institution doesn't have a right to give any authority for anybody to do anything with those ancestors. The only thing they're obligated to do is to consult under NAGPRA and repatriate the ancestors.
I am going to jump in here a little bit and say, like, it's really nice of you to say that the museum should do this, but federal agencies are very, very strict in asserting that this is their control issue and that we are not allowed to engage with tribes on collections that are from federal land and that it is their responsibility. So I'm going to push back a little bit on that and see what you all have to say about it.
Well, see, to me, it goes to that definition of possession or control, right? And the new regulations are trying to shift that. The new draft regulations have added or have included this term, what is it? Control and care.
Custody.
Custody. But to me, when I go back to the original language of the act, throughout the act, it talks about a federal agency or museum having either possession or control, then they are obligated to do an inventory. It doesn't say only those with possession or only those with control has an obligation. The problem is how the current NAGPRA regulations were drafted to confuse that kind of phraseology that the act set forward. So to me, the regulations don't fit the act. And so if we could amend the current regulations to be in line with the act's language, then too bad, federal agencies. It doesn't matter whether it's possession or control. Either way, it's just a naked form of custody. And either one or both are obligated to return and repatriate because they don't have a right of possession to begin with.
I'd like to go one step further. And I see that Melanie has stuck in there a European researcher, which I assume is tagged to the provisions for scientific testing under NAGPRA. Scientific testing under NAGPRA is possible to delay but not defeat repatriation under the stated condition that it is of major benefit to the people of the United States. So this European researcher, let's say we don't even know if we hit that threshold, but here's what I think defeats the question entirely, is that the statute says that it's permissible to complete a scientific study. It doesn't say it's permissible to start a scientific study. And so we have argued in our comments to the rules that the rules should make clear that no new studies are permissible under NAGPRA. That if you have one that was underway as of the passage of the act, perhaps you get to complete it. You don't get to do multiple iterations of it. And even that one has to be of major benefit to the people of the United States. And I don't think that this hypothetical meets either one of those.
Well, hey, could this be illegal trafficking? Is the researcher from Europe doing it for any kind of commercial gain? Is it possible to read this kind of destructive research and you're transferring part of the ancestor to anyone else for any kind of, whether it's monetary or other type of gain? Could it be seen as illegal trafficking?
It's a great question to raise at that enforcement panel next week, I think. It's funny, Judy, that you read into that researcher from Europe, because actually this is just a mashup of a real situation. And I think that probably some of you here recognize it. The situation that I encountered is in 2016, tribes called me because the researcher from Europe contacted them with the findings to say, look what I found. And the tribe said, what? What you found? Where did you get this? Where did this come from? So, these are all real scenarios that may be mashed up a little bit in my own brain. But if any of you recognize this, I was trying to look for an emoji there's no negative emojis here. If anybody recognizes this scenario, would you just hit the wow one, which is the last one? See how many wows we get. Oh, well, it's I guess it's probably time to tell you there are no right answers to these questions. That there's a million different ways you could answer them, and I think that, can the museum authorize the testing? The answer is some have, some haven't, and really, there's lots of ideas about, with Shannon and the potential for illegal trafficking here. I mean, there's lots of potential in this scenario. It's a question of, again, what's the intent, or what's the goal, what's the purpose. I'm gonna move on to the next scenario. Anybody have anything else here?
Can I just say one more quick thing? Is that to remember that NAGPRA is the floor and not the ceiling. So for those people who maybe, and there are many of you out there, I know, who work in museums as defined under NAGPRA, and you're dealing with kind of old school faculty or old school curators or directors, whatever, and you want to advocate for this closer hewing to NAGPRA in letter and spirit, that, but maybe you're getting resistance, right? University of Michigan has done a great job, and other institutions too. I know there's lots of changes within the UC system where NAGPRA is the floor and not the ceiling. So you can have internal policies that do things such as put a research moratorium on all quote unquote NAGPRA collections, right? Which they have done at Michigan. So even if it's illegally allowable or can be interpreted as such, the university has said, we recognize what this law is about and we prohibit it as an internal policy.
I think that's a great note, and Veronica, it's a wonderful analogy about the floor and the ceiling. Our last scenario here, and then we'll have some more time for a discussion and maybe getting into some questions. And I want to, just before I read this, I want to encourage you to raise your hand and come join us in a dialogue if you do have a question. All right, our last scenario is consultation. A museum has a small collection of Native American human remains and objects. In 1995, the museum submitted an inventory of the collection and indicated consultation was conducted with a professor of anthropology and the State Historical Society. There are no present-day Indian tribes in the state, and no Indian tribes are likely culturally affiliated due to the age of the remains. This determination was verified by both the professor and the Historical Society. The human remains are therefore culturally unidentifiable. The collection remains in museum storage today. Is the museum in compliance with NAGPRA?
Are we allowed to swear?
Well, I was going to make some noises and realized I wasn't on mute, so I didn't. Yeah, so go ahead, Veronica.
Hell no.
Yeah, I would say they're not in compliance. What do y'all think?
Actually, they are in compliance. They've turned in under 95. All they had to do was submit the inventory. If they determined that they were culturally identifiable, what I saw is, including UCLA, between 1995 and 1996, there were so many people checking boxes and doing the minimal amount of work in order to submit it by that time frame that they didn't do good work. They just submitted stuff. And to this day, right, we can talk about other universities that have done even more recently just to kind of be in compliance. But of course, it didn't do consultation with the tribes. So, what you saw in 1995, okay, it wasn't good. But if this was 2010, then we'd have a lot more problems because we have more clarity. So no, they didn't do the regulations because they didn't do consultation. And I will say that in 2020, I saw another one where there was no consultation and yet it was published. So I will say the National NAGPRA does not check that consultation actually does occur and that notices go to tribes. So it's always a surprise when you find out that, there's been consultation and there hasn't been. So no, we would not let this fly among our peers today. But I will say that this was something that happened over and over and over and over and over again, and still does.
And so this is what we have to kind of divide and conquer, Wendy. Just because something is a practice that everyone seems to have accepted doesn't mean that it is in compliance with a law. Just because no one seems to have fought this kind of decision making doesn't mean that this is, in compliance with the Act. So the Act clearly states that you use, and even the regulations state you use geography and consultation to affiliate ancestors, right? You use those two pieces to affiliate. Here, there was no consultation with a tribe. And the excuse that there's no present-day Indian tribes in the state is not an acceptable excuse, and it's done with complete ignorance. That every inch of the United States and Alaska are the homelands of a current tribe that could be affiliated with an ancestor. So you can't just say, oh, they're not here anymore, or this is too old. You have to do that footwork. So I don't see how, even though this has been an accepted practice in the past with the National NAGPRA program, it is not their job, or so they would likely argue, it's not their job to determine who's in compliance or who's not. They're in job to accept information and put it in their database. So it's our job as attorneys, as tribes, as whistleblowers, to say that this is in violation of law and to do something with it, which we'll find out more about next week. But the possibilities are you bring a civil complaint for failure to consult with tribes, or you potentially bring a legal case or even a dispute before the NAGPRA Review Committee to get these issues out in the open so that institutions know that this isn't okay to do. And I don't care when they did it, it still doesn't make them in compliance with the Act. It's simply a practice that we've all somehow accepted as okay.
So I want to jump in. The fact that this happened in 1995 and that it's a state that has it says no present day Indian tribes. I went to school on the East Coast, and my fourth grade teacher told me in fourth grade that there used to be Indians here and they're all gone now. And I said, oh, gee, that's too bad. And, you know, one of my day jobs is I do federal acknowledgement work, and I know the tribes that are still in that state. So that when you say no present day tribe, it may be because you're not looking. But the fact that this happened in 1995 and it and the ancestors are still sitting on a shelf leaves a problem of verifying compliance or encouraging compliance. And one of the things that needs to happen, apparently, is an examination of some of these hoary old lists that never went anywhere and didn't have consultation. And it has to be a proactive opportunity for tribes to be able to find that information in a fresher form. It also means that consultation, in a way that was not done here, needs to be defined as an affirmative obligation of anyone holding that kind of inventory. And the consultation can't stop with one anthropologist in the State Historical Society, but it has to be broadcast out far enough to say, we have found these remains. This is what we know about them. This is where they came from. There's nobody here now, but maybe some of you know who passed through. And even if the people who passed through are gone, there are certainly tribes, and you all know of them, who consider it their obligation to be custodians for people who are gone, and who can establish that affiliation at least as relatives. So that this information has to be readily available, and the obligation to consult has to be clear and verifiable. So that the regulations in determining what consultation is, it has to say there has to be an outreach, there has to be this kind of working collaboratively towards an actual result that the statute mandates. You don't get to keep these guys on a shelf because you didn't look. And I think that has to be the bottom line.
I'll add one more sort of case study, which is the joint disposition request by Michigan, all Michigan's federally recognized tribes to the University of Michigan, which in the end held about 1,500 of our ancestors. So we were trying to figure out where we had leverage in getting our ancestors back from a very resistant university and a very resistant museum and archaeologist. And I remember talking to David Tarler back then, and David, who is the attorney for the National NAGPRA program, and him saying, without consultation, you do not have NAGPRA compliance. And I hope I understood that right. I would never contradict Wendy, casually, because you are so knowledgeable. But that might be one point of maybe confusion, like how can we as NAGPRA officers, how far can we push and how strong can our accusations be?
So let me just really quickly clarify one point, at least, in that while David does have a degree as a lawyer, he is not the attorney. He doesn't practice law for the National NAGPRA program, but he does help explain the law and the regulations to people. And that's kind of his main job for me and for the NAGPRA program. I'm gonna jump in here again and say this is a real scenario, right? This is something that I've confronted, and I want to, I guess I want to be a little vulnerable and expose myself a little bit here. I think that everybody kind of sometimes it seems like I have all of this on the tip of my tongue or on the front of my head, and I don't. I often have to go back and really read what the law or the regulations say before I speak. And as Shannon was talking about consultation and the requirement for consultation, I was going to argue with her the argument I've heard from museums, which is in 1995, maybe we didn't know what cultural affiliation meant. Or if there weren't culturally affiliated tribes, who are we supposed to consult with? And when you look at the law, it doesn't say you consult with culturally affiliated tribes to complete an inventory. The law says an inventory must be completed in consultation with Indian tribes, NHOs, and traditional religious leaders. It doesn't put any qualification on that. So in this scenario, you could make a pretty strong argument that while they couldn't identify culturally affiliated tribes, the reality is they needed to find some tribe to consult with, because otherwise the inventory is not complete under the Act. Now, the regulations, they modify that a little bit, bringing in the concept of cultural affiliation or Aboriginal land as the requirements for consultation. But I think that points out, and I hope it, I hope nobody thinks I don't know what I'm talking about now, but I think it points out two things. One, that, like Shannon was saying, like, we have 31 years of this work, and sometimes we rely on experience as opposed to the words in the Act itself. And I think that the more we go back to the Act to answer our questions, whatever those questions are, whether they're in these scenarios or not, the more likely we are to get to congressional intent, whether or not that's your institutional intent or not. I think we can recognize that the congressional intent was repatriation very clearly, and the process to do that. We have quite a few questions that have popped up.
Can I just, I want to make one thing clear, like that this wasn't like something that I was supporting. I was simply stating the practice as Shannon said. And so this was kind of, I feel like I'm acting as a straw man and sort of talking about how museums have practiced the Act over the last 30 years, and say that this was certainly what I inherited, was a bunch of cases that had been submitted in order to complete the time frame that was set forth in the law. And it wasn't very good work. And then I spent the next 20 years having to go back through all of these old cases and do the consultation and bring things up to speed. And I know that a lot of other museums are facing this as well. And I do think that it was sort of the practice, and we wouldn't go by that. And I think Raylan's coalition buildings and Michigan's NAGPRA coalition, and certainly have to point out the Tohono O'odham coalition. So many people have come together in order to make it easier for museums that don't necessarily have the institutional knowledge when they're confronted with these sort of vacant terrains, as they've sometimes seen, and know that they're not true, right? That there is no empty land. It's just a matter of how can you get that information in front of museums that may not have the expertise. So I just want to make that clear, that I wasn't advocating for this
and
position.
we should recognize that, Wendy, you are the lone museum representative here, and that's you might take a lot of heat just for your willingness to be here with us. So no, I think we all appreciate and understand, and I agree with you. I mean, this is a real scenario. This is a very common example. And I couldn't agree with you more that about the way that things were done in 1995, and that we've spent a lot of time and a lot of money going back and rethinking those decisions that were made. So, ladies, where would we like to go now?
Can I bounce off one of the things you said?
Yeah.
About going back to the statute to discern intent, and that the regs as you have them were going to maybe redefine consultation with a geographic focus or with some sort of affiliation. Recommend backing off that, because if the statute says consult with tribes, you really don't want to limit that consultation. That one of the things that I found talking with everyone the last several months is there's been a lot of looking at congressional intent and going back to the legislative history. And what the first things they teach you in law school is you can always find something in legislative history to go one way and the other way at the same time. But if the statute itself picks one path, that's the path. And conflicting legislative history doesn't matter. And if I ever appear in front of the Supreme Court, you can forget that I said that.
Thank you, Judy. I think that's really important, and I think that for a lot of us engaged in this work, we do forget to return to the words in the act itself, and they're so critical um, to really understanding what our obligations are and what our rights are. Um, so we have a lot of questions. We also have about 20 minutes left for conversation. Um, I guess in my role as host or Oprah, as we joked, what do you want to do next? You want to give away a car? You want to give away a blender? What are we doing?
Under your seat.
Everybody, look
No.
under your chair.
No, if anything,
Sorry, no, there's not. If there's something there, it's yours.
we didn't do it. Let's. What do y'all think? Q&A. Q&A. Let's do it. Is Colleen going to come back for us to do that, or Melanie, are you going to?
I'm looking through them.
And of course, if anyone wants to actually come up and join us, raise your hand and we'll bring you into this with us. Don't be scared. We're all full of love.
All right, so we'll go back to the first question that was asked, and Shannon, goes back to the example you raised about the case before the NAGPRA Review Committee and the New York State Museum, and the issue of the policy of categorizing by age. Did a tribe bring this issue before the review committee? And the answer is yes. Right, Shannon?
Yes, it was the Onondaga Nation brought that claim before the review committee, and they did it in collaboration with, I believe it was the Lenape and Delaware people, because it concerned Susquehannock peoples who amalgamated into the Iroquois Confederacy, but also had connection with Delaware and Lenape peoples as well.
There's another question here that gets to the research, and that was, what would you do if your museum has a research moratorium on human remains, but you receive a request from one of many tribes whose Aboriginal territory includes the location from which the human remains were removed? I'm not sure. Oh, you receive a research request. So one of the tribes who has a connection, at least in Aboriginal territory, one of, say, many, has made a request to do research on a collection, but you have a research moratorium.
I know what I would do if I was that institution. I don't know what everyone else. If I was that institution, I would first go through, to me, it's kind of a red herring. I've got a research moratorium. That means no research. And I would make sure that the tribal consultation, affiliation, repatriation process is ongoing, and that I would leave those issues if there was disputes between tribes, among the tribes to resolve. And as an institution with a research moratorium, it would be easy to just say no, because they have a moratorium. And if repatriation moves forward, and if the tribe who wants to do research, they're sovereign, they absolutely can do research on their own ancestors if they choose to, then that would be their choice and their decision.
Knowing this case, I'm looking to see if those people are in here. I know Jan is involved, and there's a number of others that have been during this session. So I hope this helps them resolve that. But I agree. If no is no, no is no.
Oh, and this isn't. I know about 5 of these cases.
Wow.
Where one of a group of tribes has requested research. And absolutely, I think at that point you can, and in some cases you might ask the other tribes if they support the research request. And if so, then maybe you proceed. But that's kind of why you have the moratorium policy, and you can fall back on it then to say, we don't do research on Native American human remains. Okay, what happens or can happen with compliance if a museum was once a part of a state organization, but prior to NAGPRA, they became a privately operated museum? So the 1990 shuffle. We see repeatedly, unfortunately, a whole lot of what I can only term shenanigans occurring in the months before November 1990 as people tried to divest themselves of NAGPRA responsibilities. And it sounds like this is another one where a museum was a part of a state organization, but let's say July 1990, they decided, oh, we're no longer a state organization, and became a privately operated museum. Judy or Shannon, what would you advise a client to do?
Well, one of the conversations that we had in the last several months was someone pointing out that with COVID money going out to private institutions, some of those institutions might find themselves newly covered.
Absolutely. Well, and that's sorry, Judy.
Sorry, it's all right.
And that's exactly where I'd go is I'd first find out if this privately operated museum has ever received any federal funding, including, currently with the PPP and other CARES Act funding. But I'd also want to look at how a state organization turned over collections and property to a privately owned institution, and what was the mechanism of how that occurred, because that would not be, I would think, an easy matter to do, but maybe I'm wrong. So I definitely want to look into that transaction that occurred.
One other thing too that I might add, just having done activism, as a graduate student and thinking also as a journalist, that that it's okay also if there are other avenues, right? And the intention that, congressional intent is very clear with NAGPRA. And if I got stuck in this way, I would probably first go to the mission statement or the policies and procedures or ethical statements of the institution and critique that and do it in a public way and continue to educate media and not give up until they paid attention to me and heard me. And if they still aren't listening, there are other, start a blog, write an op-ed, stand out in front of the museum. There's so many things that you can do that alongside the law, and don't give up. I was working on this issue for 4 or 5 years before we even understood who to talk to at the university, besides the archaeologist who was the NAGPRA implementer for the university. And so all of those things were very effective and built lots of support in the court of public opinion, and we're don't underestimate those things, I think.
So I'm thinking of another very legalistic approach, is that if the original state institution, say we're in the state of New York, which more or less acknowledges the trust responsibility to the Indian peoples within the Indian nations within the state, that even before NAGPRA, the state institution stands as a fiduciary, and that transfer might be subject to tracing of that trust responsibility. And I'd be inclined to go after there and see if you could trace it from the original fiduciary and say you don't get to evade it that easily.
And we all have to remember that there are other laws out there besides NAGPRA. What we see often with private collections, auctions selling sensitive cultural items for private museums, is that there's often a reliance on NAGPRA. Oh, well, if it's not a NAGPRA item, then we're good, right? And that's not true. There are other state, federal, and tribal laws, because tribes never gave up their inherent sovereignty over their own cultural heritage, regardless of where it resides now. and many tribes have laws to that effect. And Judy can talk about how a tribe can hold on to jurisdiction over their cultural heritage over time, even if it's been moved. So there's other laws that are in effect that most auction houses, private dealers, and private collectors and private museums completely ignore. And we allow them to ignore on one hand because we are not activating ourselves to seek out some other solutions besides NAGPRA.
Well, I think in some ways this goes back to the control scenario, and a question of does it matter? And it matters, of course, because you need to find out who you can make a claim to, or who has a role in repatriation here. I think that I'll put in a little plug for the NAGPRA Review Committee meeting that's being held on November 12th. So during the conference on Friday, November 12th, there's a meeting of the NAGPRA Review Committee, and actually there's going to be a presentation that is kind of along these lines, not exactly, and I think that might shed some light as well on where the struggles are when it comes to these scenarios of where items are, and then how do they get returned. There's kind of a similar question here, and it, rather than read it, can you hear my dog barking this time? Sorry. Oh, just a little? Okay, I'll do this. Maybe it'll help. There's a similar kind of question, and I'm not going to read it exactly, but more summarize it, because I think that that's kind of where it goes to, and that is, let's say that there's an item that's been gifted to a person. So over 100 years ago, a tribal member gifted something to another person. And that person's family then kind of inherited that item. Eventually, that person's family loaned it to a state museum. And there's documentation for all of this, both the original transfer as well as the loans. And the family knows it's there. The question is, could the tribes repatriate it back if it's on loan to a museum? And what are the other issues that might be involved here? It reminds me a little bit, not exactly the same circumstances, of a news article from a couple of years ago out of Seattle, where a family had a Tlingit robe that was a piece of art that had hung in their dining room for years and years, and was inherited. And their daughter came home from college and said, "Why do you have this thing? This isn't ours. You shouldn't have this. This isn't art. This is a ceremonial robe that should go back to the Tlingit people." And there was a private repatriation. So I think that we can talk a lot about the specifics about who owns what and who has rights and responsibilities for NAGPRA. But maybe there's a lesson to be learned from that college student who came home and told her parents that they were doing something they shouldn't be doing. Anybody want to reflect on that, about this kind of really private collector kind of situation?
I will. So someone better speak up so I'm not the only one blabbing here.
I'll blab.
All the way.
So a lot of it goes back to whether this is like a Tlingit ceremonial robe. Is this something that should not have been possessed, and that the first person should not have given away? It's like some of the discussion earlier this morning about cultural patrimony. There are some things that, even if given away in expectation that it's a good gift, you don't have the power to give it. And if you don't have the power to give it in the first place, then you can trace that wherever it is and repatriate it. If it's in the museum, you can repatriate it. If it stays in private hands, that's a lot harder, obviously. So having regifted it or lent it to a museum, now it's in the museum's control, and now it's subject to repatriation.
Well, and that's the problem with the current regs, though, Judy, because the current regs have altered what the act says, and lays out kind of an exception that if an item is loaned, to a museum, then the museum doesn't have any NAGPRA obligations to it. So it,
I mean, that's like money laundering. You know, it's artifact laundering. It doesn't work that way.
well, that's the problem with the current regulations on that issue. But that is expressly kind of excluded in the current regulations. And that is exactly how so many private collectors and institutions have come together and brought in some really sensitive items that should not be in their hands to showcase and to provide exhibits for. I could name a handful of institutions doing that right now if anybody would like me to. And that's how they get away with it.
Well, and there was some conversation in one of the sessions earlier, kind of related to that, and a collection that's on loan at the Metropolitan Museum of Art in New York City. I just put in the chat the definition of possession in the current regulations, which does explicitly talk about loans.
And if we go back to the Act and the Act's language, where possession or control is kind of always together, right? It's never separated into two separate terms. It says it doesn't matter if you have possession or control, you still have these NAGPRA obligations. And then the regs split up possession and control as two separate things, meaning two totally different things. So there's possibility there. Hopefully in the new NAGPRA regulations that we see something that's closer to what the Act's language originally intended. So that private collectors and institutions can't, obfuscate NAGPRA compliance by calling something a perpetual loan.
Can we cast this as a different hypothetical where instead of this being someone's bracelet or somebody's arguable piece of artwork, it's that this family has always had this, ancestor in the basement because that's who they are, and they lend that to a museum. Does anybody really think that getting it from a wrongdoer in the first place makes it okay if it's only a loan?
It's an interesting question because then it goes back to let's look at the Act and how it defines what right of possession is, right? And the only way that an institution can show that they have a right of possession is by proving that they had the tribe's authority to receive the item. So if that individual who had the item and gifted it to someone, if they did not, even if it was a citizen of that tribe who took it out of the collective ownership, if they didn't have the authority to do that, then they couldn't have gifted it to anyone else outside of the tribe. So then whoever they gifted it to wouldn't have the right of possession.
Yeah, which this comes back to is what we were harping on before, is that you only have a right of possession as an institution if you can show that when the object was severed from the place it was supposed to be, that it was rightfully gifted to the person from whom that after it came out of the ground, after it came out of where it became, and nothing cleans it after that. Nothing cleans it after that. So that if the original dispossession was not with appropriate consent, not spurious consent, but appropriate consent, then it becomes an object of obligated repatriation once it gets into a place, once it gets into the control of some entity that has an obligation to repatriate, period.
Is the Haida case that Walter Echo Hawk argued before the NAGPRA Review Committee in 2010 a good example of that. I think it was Haida, wasn't it Haida? I'm sorry if there are Haida people on this call and I'm messing up. But I believe that there is strong precedent for this. And I remember seeing Walter Echohawk arguing very beautifully on behalf of cultural patrimony for a tribe about this. So NAGPRA review committee proceedings can be helpful and are available.
I think this has been a really rich conversation, and I personally wish we could continue for hours to come, but I know that we can't. And I also know that there are polls that I think Colleen or Shannon wanted to launch as we're in our last 3 minutes together. I just want to take an opportunity to thank all of you for sharing your thoughts about some of these questions and putting up with my red herrings and engaging in some really, I think, constructive conversation around some very specific scenarios. And I think that there's so much to learn from this.
All right, smash that yes or no.
Ooh, be careful. The
Yeah.
no is on top. This is
Colleen.
the first time today.
Colleen is making people work for it.
You got to think about, don't just click.
Don't just smash anything. Very cool. All right, we have 2 more. Does anyone, Wendy, Veronica, Judy, does anyone want to have some final words while we're doing polls?
I'm gonna keep pressing. I mean, this is really interesting about the idea of the loan scenarios, because obviously that was a big way in which people were getting out of. It was a purposeful tactic that was being used in order to not have to do repatriation, and I think it did put a lot of people in a bind. And now they're starting to come out. And I want to mention that it's really important for campuses, for university campuses, to check all their closets in all the departments for things that have been left, and that there's a lot that's coming out in radiocarbon dating labs and DNA labs and in old offices and with retirees. And so we really have to do this heavier lifting than just allowing it to continue to slide by and like, oh, I'm too busy here, so I can't take care of that. We really have to get, we have to see the museums to do more work, and universities.
I agree with what Wendy said, and I will add, don't forget to, or don't ever assume that your retiring faculty, especially old school faculty, did not bring home their collections. We're hearing more and more stories of this, of people removing remains, DNA material and objects. And they're going back to the faculty members' private homes because they have an inappropriate understanding of their possession of that. And then also, I just want to say one more thing, like for my fellow NAGPRA implementers, my tribal repatriation officers, I just want to say, please do not feel self-conscious or discouraged if you don't feel like you have an encyclopedic, knowledge and authority over this law. Almost everybody I know learned on the job, and that's okay. And you will continue to learn. And the way I try to think about it is that the ancestors are still teaching us. So just be determined in your work and know that you are among people who share that hard work with you.
I was trying to point out exactly how I just learned on the job during this session.
Thank you all. This has been